specifically deals with penalties for violations of certain provisions of the Fair Labor Standards Act, FLSA, which regulates minimum wage, overtime pay, child labor, and record-keeping requirements for covered employers. A. Fines and imprisonment. Any person who willfully violates any of the provisions of Section 215 of this title shall upon conviction thereof be subject to a fine of not more than $10,000, or to imprisonment for not more than 6 months, or both. No person shall be imprisoned under this subsection except for an offense committed after the conviction of such person for a prior offense under this subsection. B. Damages, right of action, attorney's fees and costs, termination of right of action. Employers who violate the stipulations outlined in Sections 206 or 207 of this title face significant repercussions under the law. Any such violation results in the employer being held accountable to the affected employee or employees for their unpaid minimum wages or overtime compensation, with an additional equal amount awarded as liquidated damages. Similarly, violations of Section 215a, 3, or 218d of this title render employers liable for legal or equitable remedies necessary to uphold the aims of the respective sections, including employment reinstatement, promotion, and the reimbursement of lost wages, plus an equivalent sum as liquidated damages. Additionally, infringements of Section 203m, 2b, lead to liability for employers equivalent to the sum of any tip credit taken unlawfully, alongside all unlawfully retained tips, with a further equal amount awarded as liquidated damages. Employees are empowered to pursue action against violators, whether private or public entities, in federal or state courts, representing themselves and others in similar situations. Consent from an employee is required for them to join such actions as party plaintiffs, and the court, in addition to any judgments issued, is authorized to grant reasonable attorney fees and costs to the prevailing party. However, the right to bring forth such action ceases upon the Secretary of Labor filing a complaint under Section 217, either seeking the prompt payment of unpaid minimum wages or overtime compensation or pursuing legal or equitable remedies for violations of Section 215a, 3, or 218d. C. Payment of wages and compensation, waiver of claims, actions by the Secretary, limitation of actions. The Secretary holds authority to oversee the payment of any outstanding minimum wages or overtime compensation owed to employees as stipulated in Sections 206 or 207. Should an employee agree to accept such payment, it constitutes a waiver of their rights to pursue unpaid wages or compensation under subsection B of this section, along with an equivalent sum as liquidated damages. The Secretary is empowered to institute legal action in any court of competent jurisdiction to recover unpaid wages or overtime compensation, along with liquidated damages. However, the right provided by subsection B for employees to bring forth actions or join as party plaintiffs ceases upon the Secretary filing a complaint seeking recovery of unpaid wages or compensation under Sections 206 and 207, unless the action is dismissed without prejudice upon the Secretary's motion. Any amounts recovered by the Secretary on behalf of employees are deposited into a special account and disbursed directly to the affected employees upon order by the Secretary. Unpaid sums remaining after 3 years are transferred to the Treasury of the United States. Commencement of an action by the Secretary under this subsection, for statute of limitations purposes, is considered to occur on the date of filing the complaint or on the subsequent addition of the individual claimant's name as a party plaintiff. These provisions also apply to violations of Section 203m, 2b, with the employer being liable for any tip credit taken unlawfully, in addition to unlawfully retained tips, along with an equivalent sum as liquidated damages. D. Savings provisions. In any legal action or proceeding initiated prior to, on, or after August 8, 1956, employers are not liable or subject to punishment under this chapter or the Portal-to-Portal Act of 1947 for any failure to comply with the provisions of this chapter or said act under specific circumstances. These circumstances include instances where the work is performed in a workplace exempted under Section 213f of this title, or where work was performed in Guam, the Canal Zone, or Wake Island before the effective date of the amendment of subsection D. Additionally, employers are not held liable for non-compliance with provisions concerning work performed in a possession named in Section 206(a)(3) of this title before the establishment of a minimum wage rate applicable to such work by the Secretary, as stipulated therein. E. Civil penalties for certain violations. 213(c) of this title, primarily concerning child labor, or any related regulations. The penalties for such violations may not exceed $11,000 per affected employee or $50,000 for each violation resulting in the death or serious injury of an employee under 18 years of age. The latter penalty may be doubled for repeated or willful violations. Serious injury is defined to encompass permanent loss or substantial impairment of senses or bodily functions, as well as paralysis or impairment resulting in the loss of movement or mobility. Additionally, penalties up to $1,100 per violation may be applied to individuals repeatedly or willfully violating wage-related sections 206 or 207, or section 203(m)(2)(b), regarding tip regulations. The size of the violator's business and the severity of the violation are taken into account when determining the penalty amount. Final penalties may be recovered from the United States owed sums, through civil actions brought by the Secretary of Labor, or as ordered by the court in relevant actions. Administrative determinations of penalties are deemed final unless contested within 15 days, triggering an administrative hearing process. Penalties collected are utilized to cover the costs associated with determining violations and collecting penalties, except those collected for Section 212 violations, which are deposited into the general fund of the Treasury.
I would normally say good afternoon, but good morning, everyone. Welcome to City Council's legislative agenda today. We are going to start with our land acknowledgement, and I want to thank the citizens of Spokane for being flexible and accommodating in our situation that happened on Monday. We acknowledge that we are on the unceded land of the Spokane people, and that these lands were once the major trading center for the Spokanes, as they share this place and welcome other area tribes through their relations, history, trade, and ceremony. We also want to acknowledge that the land holds the spirit of the place through its knowledge, culture, and all the original people since time immemorial. As we take a moment to consider the impacts of colonization, may we also acknowledge the strengths and resiliency of the Spokanes and their relatives. As we work together making decisions that benefit all, may we do so as one heart, one mind, and one spirit. We are grateful to be on the shared lands of the Spokane people and ask for the support of their ancestors in all relations. We ask that you recognize these injustices that forever change the lives of the Spokane people and all their relatives. We agree to work together to stop all acts of continued injustices toward Native Americans and all our relatives. It is time for reconciliation. We must act upon the truths and take actions that will create restorative justice for all. Today, in honor of Veterans Day, I'd like to ask Mr. Will Hewings, a vet, to lead us in the Pledge of Allegiance. Will you all stand, please?
Thank you, Betsy. All right. I pledge of allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much, Will, for your service. Ms. Pfister, will you call the roll?
Council President Wilkerson.
Present.
Councilmember Sapone.
Here.
Councilmember Cathcart.
Present.
Councilmember Bingle.
Here.
Councilmember Dillon.
Here.
Councilmember Klitsky.
Present.
Councilmember Navarrete.
Here.
Let the record reflect that all council members are present.
Thank you. We are now actually in briefing session, and we're going to start with a board and commissions interview from Justice for All for the Human Rights Commission. Justice, come on down. Welcome.
Hi, thank you for having me.
Got to have you. Just tell us a little bit about yourself and why you're interested in this position.
My name is Justice for All. That is my given name. I've lived in Spokane since 2016 and started a lot of my human rights activism in Spokane. First starting at the intermodal station, but doing a lot since then. I feel like I've grown both as an activist and as a human being, learning a lot from a lot of my peers, including, and a lot of people I respect who are up on the city council as well. Yeah, it's been quite a journey, and I say that I definitely have a big heart